Hi, welcome to our channel of IGNOU audiobooks, Indira Gandhi National Open University, School of Law, SOL, Diploma in Paralegal Practice, DIPP, BLE-001 Introduction to the Indian Legal System, Block-1 Rule of Law, Principles and Concerns, Unit 1 Rule of Law. 1.1 Introduction. Do you believe that the law should protect everyone equally and punish the wrongdoer, irrespective of his/her caste, race, religion, and status? Or should there be different laws and procedures to govern different persons? These are a few questions that might arise when you study any legal system. Learning the concept of rule of law enables you to address these questions in a positive frame of mind. Every country has a set of legal rules that apply to all citizens or a distinct set of people. The fundamental principle of a democratic nation is that no one is above the law, which is also known as rule of law. Rule of law makes everyone subordinate to the law, irrespective of his/her status in the society. Under rule of law, the law does not recognize the status of a person for both protecting rights and punishing for violations. Therefore, rule of law is a fundamental value on which rests any democratic political system. Rule of law refers to a government subject to the law and a system in which the law will prevail over the whims of government officials. The officers of the government are as equal before the law as any ordinary citizen. It denotes equality before the law and absence of arbitrary powers with government officials. Accordingly, no bureaucrat or minister, not even the king, is above the law. Every person, no matter what position he holds or what powers he otherwise exercises, is equal before the law. The term, rule of law, is derived from the French phrase la principe de l'égalité. The principle of legality, which refers to a government based on principles of law and not of men. Thus, rule of law not only advocates equality in protection and punishment, it also means absence of arbitrary exercise of power by government. Rule of law subjects every governmental action to the test of legality. That is, all official action should be legal. For instance, if a minister gives an arbitrary order, it will be against rule of law and the courts can quash such an order. The minister, as in this example, will not be allowed to keep himself/herself above the law, and she will not be given any immunity as far as an illegal action is concerned. Therefore, rule of law is a key index that determines the quality of good governance in a country. In this unit, we will discuss the concept of rule of law and its principles, and how it has been imbibed in the Indian Constitution and the legal system. We will also explore the challenges faced by our nation in implementing rule of law. 1.2 Objectives. After reading this unit, you should be able to explain the concept of rule of law, state the principles of rule of law, explain the necessity and efficacy of rule of law, demonstrate how rule of law has been imbibed in the Indian legal system, and identify the challenges in implementing rule of law in the present-day context. 1.3 Dicey's thesis on rule of law. The concept of rule of law is of old origin. Edward Coke is said to be the originator of this concept, when he said that the king must be under God and law. This was against the age-old belief that the king can do no wrong, and that the king makes the law and therefore is above the law. In India, the concept can be traced to the Upanishads, which provide that law is the king of kings. It is more powerful than the kings. There is nothing higher than law. Professor A.V. Dicey developed this concept in the course of time and expounded the concept of rule of law in his treatise, Law of the Constitution. As per A.V. Dicey, the rule of law is based on three principles depicted in the following figure. Look at the screen. 1.3.1 Absence of arbitrary power. It is not possible for any government to function effectively unless government officers are allowed to exercise discretionary power. Discretionary power means the power to act in the way the officer deems fit, which may result in the abuse of power by administrative officers.
When Professor Dicey formulated the concept of rule of law, he was very well aware of the harm that might result from the use of power by state officials. Therefore, he advocated that arbitrary power shall not be conferred on any officer. Arbitrariness denotes unreasonableness and is against all norms of law and justice. The officers have to carry out the law made by Parliament and should not exercise any more power. Main features. No person could be punished or made to suffer in body or property except for breach of law. The state cannot punish any person except for violation of law. Any wide discretionary power or arbitrary power vested in the state violates rule of law. In the most fundamental sense, this principle attempts to protect the citizens from arbitrary and abusive use of government's power. The authorities who are empowered to act must do so in accordance with the law. For example, if a transport director is given uncontrolled discretionary power to allow or refuse or cancel permits for running public transport buses, his power may result in arbitrary cancellation as well as allotment of bus permits. He may act as per his whims and interests, in any unreasonable or arbitrary way. So Dicey suggested that the officers are not to be given any power that would lead them to act arbitrarily. According to Dicey, wherever there was discretion, there was room for arbitrariness. Rule of law is against any form of arbitrary action on the part of the government. Any unreasonable or arbitrary action is considered to be illegal. Therefore it can be nullified by a court of law. Activity. Analyze the governmental action in the following instances and identify the presence of arbitrary power, if any. Government issues an order for acquisition of private property after paying reasonable compensation to the property owners. The purpose for acquisition is not mentioned in the order. The line of shops on one side of the market road is accordingly ordered to be vacated within 15 days. The shopkeepers are not given any chance to present their objection to the said order. The government notifies to withdraw the recognition of all primary schools, which do not comply with the safety requirements, as specified in a law passed by the Goa legislature. The school authorities are given 6 months' time to adapt to the requirements. The Minister of Petroleum is given the power to allot petrol pump outlets as he thinks fit. He makes all the allotments to his near friends and relatives. In the first illustration, the order is arbitrary and against rule of law because the government is exercising uncontrolled power. The shopkeepers are not even allowed to voice their claims. In the second illustration, government is merely implementing the requirements as mentioned in the law made by the legislature. In the third illustration, the minister's action is totally arbitrary and violates rule of law. Thus we can see that the principle underlying rule of law is that the government executive must act under the law, and not by its own whims and fancies. The executive does not have and cannot have any power of its own. Whatever power it exercises are given to it by a law made by the legislature. You are listening to this audiobook on Audio Learn IGNOU. 1st March 2002, Equality before the law. Rule of law not only means that no person is above the law, but also that everyone, irrespective of his her rank or status, is subject to the ordinary law and to the jurisdiction of ordinary court. It means universal subjection of all classes to one law administered by ordinary court. Universal subjection means that every person from Prime Minister to clerk is under the same responsibility and liability for violation of law. Every person is subjected to one and the same body of law. In any polity, disputes may arise between individuals and also between individuals and the government. According to A.V. Dicey, equality before law denotes application of the same system of law and procedure to all such disputes, irrespective of whether government is a party or not. Different laws and different procedure to deal with disputes wherein the government is a party violates rule of law. Any such attempt would amount to protecting government officials. Therefore, the legality of the acts of the government should be decided by the same courts that are independent of the executive. Main features. All are equal before the law. Every person is liable for breach of law, irrespective of his her status. No special treatment or privileges for government officials. Government officials are liable for breach of law, just like any ordinary citizen. No separate courts to deal with disputes between government and citizens. All disputes are subjected to the jurisdiction of the same courts. Courts must be independent of the executive. Illustrations. 1. An university makes a rule allowing only persons working in the government sector to take admission in evening college. This would be violative of equality before law as it discriminates between government servants and non-government servants. 2. Government announces a policy to give preference to less educated persons over more educated ones in the matter of appointing dealers for ration shops. Thereafter, appointments are made exclusively on the basis of interview. This policy violates the principle of equality before law, as the less educated are given special treatment over those who are more educated. 3. Parliament passes a law stating that only graduates shall have the right to vote for the Lok Sabha elections. Such a law would be violative of equality before law because a valuable right of the citizen is denied on the ground of lack of educational qualification. Here, graduates and undergraduates are treated differently by the law. Such a differential treatment is against the concept of treating everyone equally before the law. 1 March 2003, Supremacy of Law. The general principles of British constitutional law, which is unwritten, are developed by the decisions of courts, especially individual rights. As these rights are recognized by the courts and subsequently got constitutional status, Dicey viewed them as supreme and having higher protection from violation. He described it as predominance of the legal spirit. The first two principles of rule of law become meaningless when they cannot be secured by courts. Therefore, the essence of the third principle is that the citizens should be able to enforce the rights that are recognized and the courts must be sufficiently empowered for that purpose. Dicey opined that mere recognition of these rights by a written constitution would not automatically promote rule of law, as many written constitutions in the world also enumerate exceptions wherein these rights cannot be enforced. Further, the constitutions may also make it permissible for Parliament to amend these rights. For example, Articles 358 and 359 of the Indian Constitution permit the President of India to suspend certain fundamental rights during a national emergency. Article 368 empowers Parliament to amend the Constitution. Further, to promote the supremacy of law, a system of strong, independent and impartial courts is mandatory. Main features. Mere enumeration of rights is not sufficient. Recognized rights should have proper remedies for violation. Rights should be enforceable in court. Courts should have the power of judicial review. Courts need to be empowered to protect the rights of the citizens. 1.4 Rule of Law in India. 1 April 2001 Rule of Law and the Constitution of India. A state is generally viewed as just an independent political entity. In this narrow view, the functions of the state are restricted to maintenance of law and order and protection of the nation from external invasion. However, a modern state has become more complex and carries out a wide range of functions. For example, government controls the economic, social and political relations of citizens. Government carries out its activities through basic organs such as the legislature, executive and judiciary. These organs are governed by a fundamental law called constitutional law. Constitutional law being the fundamental and the highest law of the land, all other laws in the nation need to be consistent with the philosophy of the Constitution. Moreover, the three organs of the government having been created by the Constitution are also subject to it. Therefore, recognition of rule of law by the Constitution would automatically ensure rule of law in the nation. Rule of law is amply imbibed in the Constitution of India. It runs as a golden thread through the fabric of Indian Constitution. Several provisions in the Indian Constitution apparently promote the idea of rule of law. Absence of arbitrary power, the first principle of rule of law, can be traced from the following provisions of the Constitution of India. 1. Right to equality under Article 14 of the Indian Constitution includes right against arbitrary use of power by the government. Supreme Court in EP. Royappa v. State of Tamil Nadu, AIR 1974 SC 555, and Maneka Gandhi v. Union of India, AIR 1978 SC 597, held that Article 14 embodies a guarantee against arbitrariness. Equality is antithetical to arbitrariness, and any government action that is unreasonable or arbitrary denies equality, and is void. Article 14 not only strikes at arbitrariness in executive or administrative action but also legislative action. Therefore, Article 14 imposes an obligation on the government to act in a just, fair and reasonable manner. 2. Right to life and personal liberty under Article 21 requires the government to act justly, fairly and reasonably in matters of life and liberty. 3. Article 245 read with 7th schedule of the Indian Constitution deals with distribution of legislative power between centre and state. This constitutional scheme prescribes 3 lists such as central list, state list, and concurrent list. Under this scheme, central government can pass law only on subjects mentioned in central list, state government can pass law only on state list, and both centre and state governments can pass a law on the concurrent list. Equality before law, the second principle of rule of law, can be traced from the following provisions of the Constitution of India. 1. The preamble of the Constitution of India intended to secure equality of status and opportunity. 2. Articles 14 to 18 in Part 3 of the Indian Constitution guarantee the fundamental right of equality. Article 14 provides for equality in general and states that every person is equal before the law and state shall provide equal protection to all persons. Article 15 prohibits the state from discriminating against its citizens on grounds of race, religion, caste, sex, and place of birth. Article 16 guarantees all citizens equality of opportunity. Article 17 prohibits the practice of untouchability, whereas Article 18 prohibits titles. 3. In several cases, the Supreme Court held that right to equality is a basic structure of the Constitution and could not be abridged or amended. Even though Article 14 confers equality as a fundamental right, it does not mean absolute equality. Equality means equality among equals, and like must be treated alike. 4. Therefore, special treatment for different people is not a violation of Article 14. For example, reservations for backward classes, different tax slabs on the basis of income is not against equality. Similarly, different courts to deal with different cases do not violate equality, as the special courts are also under the supervisory jurisdiction of the ordinary courts. Supremacy of the law, the third principle of rule of law, is well recognized by the Indian Constitution under Articles 13, 32, and 226. 1. Article 13 expressly provides for judicial review over the legislations passed by the legislature. Under this article, no law, made before or after the enactment of our Constitution, should violate Part 3 of the Constitution. Any such law would be void. This protection was extended even to the rules, regulation, executive orders and customs having force of law. 2. Article 32 confers writ jurisdiction on the Supreme Court, under which the court has power to issue any order or grant any relief for violation of fundamental rights. This jurisdiction of the Supreme Court cannot be restricted, except according to the provisions of the Constitution. Right to approach the Supreme Court under Article 32 itself is a fundamental right. 3. Article 226 confers similar jurisdiction on high courts. High courts can exercise writ jurisdiction. Any law restricting the jurisdiction of the court under Articles 32 and 226 would be null and void. 1.4.2 Rule of Law and Administrative Law in India. In a welfare state, the government has countless functions to perform. To mention a few, it has to take care of law and order, protect the country from external aggression, provide welfare services like healthcare, education and housing schemes, provide public utility services like water supply and electric supply. It also has to control the market to ensure quality of goods and make available essential commodities at a fair price. There is, in fact, no end to the list of governmental functions. To perform this huge task, the government confers powers on its officers and imposes duties on them. The chances of corruption and abuse of power are more when more powers are given to the officers. Administrative law is a branch of law that helps to control governmental exercise of power. Administrative law deals with the powers and functions of government officials, and control mechanisms over their use of power. Therefore, we can see that the focus of rule of law and administrative law is one and the same. Both aim at control of power and prevent arbitrary use of power by officials. However, it is noteworthy to mention here that when Dicey formulated his rule of law, he thought that administrative law was against rule of law. Let us see this conclusion drawn by Dicey in the form of a logical premise. Statement 1. Administrative law deals with giving of powers, that to discretionary power, to officers. Statement 2. Wherever there is discretion, there is scope for arbitrariness. Statement 3. Rule of law is against arbitrariness. Inference. Dicey's administrative law is opposed to rule of law. This inference has been proved to be wrong because administrative law deals not only with conferring of powers on the officers, but also focuses on controlling the powers of the government. It is administrative law that makes it possible for the courts to strike down any arbitrary exercise of power by the government. Moreover, as Dicey thought, absence of arbitrary power need not necessarily mean absence of discretionary power, for the reason that a welfare state can function effectively only if such powers are given to the executive officers. In reality, administrative law does not infringe upon rule of law. On the contrary, administrative law, being a system of control of administrative power, promotes and strengthens rule of law. As discussed, the scheme of the Constitution of India is based on the concept of rule of law, wherein any authority is under the supremacy of law. Rule of law requires that any abuse of power by a public officer should be subject to control of courts. The Supreme Court of India and the various high courts are authorized by the Constitution of India to strike down any arbitrary action on the part of the government. The concept of rule of law is often invoked to challenge unreasonable governmental action. The whole idea is that administration cannot exercise arbitrary powers and that it should function in accordance with the law. The obligation to act fairly on the part of administrative authorities was evolved by the courts to ensure rule of law and to prevent failure of justice. It is a fundamental norm of rule of law that every governmental action shall be fair. Any action that is unfair tends to be arbitrary, and the first principle of rule of law, as we have already seen, is absence of arbitrariness. To ensure fairness in governmental action, courts have developed the principles of natural justice. There are two main principles of natural justice, namely 1. Rule against bias. 2. Audi alterum partem, or rule of fair hearing. Rule against bias means that no one shall be a judge in his own cause. This aims at settlement of disputes by an impartial judge. It also means that any governmental authority exercising a decision-making function should be impartial and should not have any interest in the subject matter of the dispute, also as he should not be partial towards any party to the dispute. For example, if a member of an interview-selection committee is also a candidate, it would amount to bias and therefore a violation of natural justice and rule of law. Audi alterum partem means, here the other party. That is, the judge shall not decide a matter unless both the parties are given an opportunity to present their case. Similarly, when any administrative authority is taking an action which affects the rights and liabilities of a person, natural justice demands that the person would be given a right to be heard. For example, if a government employee is dismissed from service, as he should be given an opportunity of being heard before the dismissal order is passed. If such a chance was not given to the employee, the dismissal order would be violative of natural justice and therefore against rule of law. Further, rule of law would be strengthened if the executive were to be required to formulate its reasons when reaching its decisions, and to communicate them to the concerned party. The Supreme Court of India has held in Indira Gandhi v. Union of India, AIR 1978 SC 597, and more clearly in Tulsiram Patel v. Union of India, AIR 1985 SC 1416, that non-observance of the principles of natural justice in state action is violative of rule of law. Thus, the principles of natural justice aim at promoting fair governance, which is the main concern of rule of law and of administrative law. Thus, Indian administrative law has benefited from rule of law by way of establishing judicial review of administrative action to ensure that administration acts in accordance with law. You are listening to this audiobook on Audio Learn IGNOU. 1.5 The wider meaning of rule of law. Rule of law can be understood and applied in two senses, i.e. 1. Formalistic narrow sense. 2. Ideological wider sense. In the formalistic sense, rule of law merely means that the government should be subject to law, so that law will prevail and not government officials. Usually rule of law is defined and understood to be a formalistic application of the principle of equality, adequate control over governmental power and supremacy of the judiciary. However, in developing and underdeveloped countries, rule of law means much more than these. Improving the quality of life and ensuring safe and healthy living conditions all go towards securing a just democratic order. Hence, the wider meaning of rule of law assumes significance.
In its ideological sense, rule of law represents an ethical code for the exercise of governmental power. Such an ethical code would necessarily contain within it accountability and respect for human rights. The holders of public power should be made accountable for the exercise of their power. A government that fails to respect and promote human rights would invariably be deviating from the concept of rule of law. The modern concept of rule of law was developed by the International Commission of Jurists, ICJ. According to this formulation, the rule of law is a dynamic concept and implies the following principles. The individual is possessed of certain rights and freedoms and that he is entitled to protection of these rights and freedoms by the state. There is an absolute need for an independent judiciary for ensuring effective machinery for the protection of fundamental rights and freedoms. Equal access to justice. The primary obligation of the legal profession is to use its best efforts to ensure that adequate legal advice and representation are provided. This would include extending free legal aid to the poor. The establishment of social, economic and cultural conditions would permit all individuals to live in dignity and to fulfill their legitimate aspirations. This would include recognition of civil and political rights as well as the establishment of the social, economic, educational and cultural conditions, which are essential for the full development of the individual's personality. The modern concept of rule of law is especially important in third world countries, where, in reality, the principles of rule of law, absence of arbitrariness, equality before law and predominance of the legal spirit, will prevail only if the government creates socio-economic and politico-cultural conditions in which the dignity of individuals can be realized. 1.6 Concerns. Strict implementation of rule of law in a legal system like India poses several serious challenges. The socio-economic and political conditions in India raise many concerns on effective implementation of rule of law. Some of the concerns challenges are listed below. However, this list is not exhaustive. 1. Poverty. Offering special treatment by way of reservations may per se appear to be a violation of rule of law. However, several decades of exploitation and uneven distribution of wealth in India has resulted in rendering certain sections of the people backward. 2. Fundamentalism and communalism. Religious intolerance, particularly against minorities, would seriously undermine the role of rule of law. Further, this situation becomes even more complex due to special protection conferred on minorities by the Constitution. 3. Regionalism. Rise of regionalism endangers the unity of the nation. Demand for special treatment on the basis of demographical area severely weakens the rule of law. 4. Terrorism. Terrorism and terrorist attacks on the public life demands stringent laws. Laws enacted to counter terrorism, particularly preventive detention laws, would confer a lot of discretion on law enforcement agencies. This discretionary power might result in arbitrariness, and hence violates rule of law. 5. State violence, violation of law by law enforcing agencies like the police and armed forces, particularly in cases of arrest and detention, would have a severe impact on rule of law. This is more so as the government may not be interested in punishing these agencies as they form part of government machinery and to uphold the law and order. 1.7 Summary. Let us sum up what we have studied in this unit. We discussed the concept of rule of law and how important it is in making democracy meaningful. We also learned the 3 principles of rule of law as formulated by A.V. Dicey. We further discussed the adoption of rule of law in India. Under this section, rule of law, we analyzed how rule of law was imbibed in the Constitution of India. Further, we also learned various provisions under the Indian Constitution dealing with rule of law. We saw how rule of law, though viewed as an objection to administrative law, actually strengthened the administrative law. We also understood how the principle of natural justice promotes rule of law in administrative law. We then examined how the scope of rule of law widened, particularly in the third world context. We also discussed the concerns and challenges that lie ahead for effective implementation of rule of law. Thank you. Subscribe our channel for more updates. We will see you with the next chapter.